Great. Thank you all so much for joining this bi-monthly immigration litigation roundtable with Amica Center for Immigrant Rights and our Immigration Impact Lab team. I'm really happy to have our speakers today, both from our Immigration Impact Lab team and our detained adult program that's doing a lot of these cases we'll be talking about as well. So we have Emily Reber here, who's a senior attorney with the lab team, and Catherine Gordon, also senior attorney with our detained adult program. And today we're focusing on everything going on with bond and habeas, given the decision matter of Yajure-Hurtado, which essentially cut off bond eligibility per the perspective of EOIR and the current administration for really the vast majority of people that we see in ICE detention. And we're going to be speaking about a class action, Maldonado Bautista, that has had impact on this and where litigation is ongoing regarding these matters. So we really want to hear from you all and what you're seeing on the ground in immigration courts and bond hearings. Want to hear if you've been trying habeas for these types of claims. So please do participate in the chat or come off mute if you want to have something to add as we continue on. First, just a little bit about Amica Center for Immigrant Rights. If you are new to our community, thank you for being here. My name is Adina Applebaum. I'm the program director of our Immigration Impact Lab team. Our organization is primarily a direct services legal service provider. We work with adults and children that are detained by the government and facing deportation. We've been around for over 25 years doing this work, and we are based in Washington, D.C., but we do work with clients really all over the country now as ICE our transfer people at an increasing rate. We focus on defending one another, and we engage in unwavering legal defense and strategic litigation. We believe that everyone deserves access to due process and legal representation. Our Immigration Impact Lab team I mentioned is where we house the impact litigation work, and where traditionally we've housed a lot of our habeas litigation in the organization, although we do have attorneys from across the org now involved in habeas, given the need right now, including in our detained adult program that Catherine will share her perspective from. A little bit about just kind of our approach to impact work. Because we're a direct services group, we're often focused on individual cases and leveraging those to help the person impacted and broader groups of immigrants, and making good law when we can in these times. A lot of our cases now do originate out of district court and sometimes go up on appeal. We also do class action work, group habeas, petitions for review in the circuit court, FOIA litigation. So with all that being said, I will pass it over to Emily to kick us off.
Hi, everyone. Thanks for joining us for our February roundtable. First, I'll be covering some BIA and litigation updates, specifically Yajure-Hurtado and Maldonado Bautista. And then I'll be covering some habeas strategies, since release from detention is now primarily by way of federal court. And then my colleague Catherine will be covering bond strategies, since now, upon returning to EOIR for custody redetermination, it's increasingly more challenging to win bond. In July of 2025, ICE issued a memo saying that those present without inspection were subject to mandatory detention. And then the BIA issued matter of Yajure-Hurtado on September 5th of 2025. Mr. Yajure-Hurtado entered the United States without inspection in November of 22, was granted TPS in 2024, and then after his TPS expired in 2025, was arrested by DHS. He requested a bond hearing in immigration court, and the immigration judge concluded that the court lacked jurisdiction over the custody redetermination proceedings. The decision went up on appeal, and the BIA decided that individuals in Mr. Yajure-Hurtado's position are subject to mandatory detention under INA 235B. This was a significant change from BIA precedent and DHS practices. 235B2 and 236A were enacted as part of EOIR, the Illegal Immigration Reform and Immigrant Responsibility Act in 1996. And the legislative history associated with EOIR demonstrates that those present without inspection are by default under discretionary detention 1226A. And the regulations enacted after EOIR also confirmed that 1226A is the default provision. The BI's decision was also contrary to decades of enforcement practices, and most recently, the Lake and Riley Act has a new provision, 1226C, which mandates detention for non-citizens charged or arrested for certain crimes when they're inadmissible for, among other things, being present in the United States without being admitted or paroled. And as you can guess, this provision of the Lake and Riley Act would only have meaning if those present without inspection prior to the Lake and Riley Act were not subject to mandatory detention. So the impact of this is now individuals need to file habeas petitions. They are a significant barrier to release on bond, either trying to find counsel and preparing for and litigating and winning a case in federal court, or attempting to proceed pro se. Regardless, having to prepare for and litigate habeas cases extends the length of detention, although these cases are now in some jurisdictions being adjudicated quite quickly. And of course, there's always the possibility of getting one of those few federal judges that are agreeing with the BIA. Next, I want to cover Maldonado Bautista, a class action in the Central District of California. The complaint in this case was filed in July after ICE's memo, but before the BIA's decision in matter of Yajure-Hurtado. This was on behalf of a group of plaintiffs, which the class included if someone did not have lawful status and was currently detained, those who entered without inspection or without being apprehended, and they were not detained under some other provision for mandatory detention. In November, the district court entered partial summary judgment on behalf of the individual plaintiffs. And then several days later, the court certified a nationwide class and extended the declaratory relief from the individual plaintiffs to the class. Declaratory relief, in theory, has the full force and effect of a final judgment, and the advisory committee's note to Federal Rule of Civil Procedure 23 provides that declaratory relief corresponds to injunctive relief when, as a practical matter, it affords injunctive relief or serves as a basis for later injunctive relief. However, in practice, we're not seeing declaratory relief have the full force and effect of a final judgment in EOIR. The reaction within EOIR before clarification, before the judge issued a clarification decision in December, was that the court had not entered a final judgment. And so EOIR did not have to follow Maldonado Bautista. But then the plaintiffs moved for a clarification. The court entered final judgment on December 18th. And as we've seen since then, IJs are still not following Maldonado Bautista despite having the final judgment. After December 18th, we're also seeing DHS attorneys being directed to argue that Yajure-Hurtado still controls without providing much reasoning in cases where in bond hearings where there has not been a habeas petition granted. There have been several cases where the government has conceded that Maldonado Bautista entitles class members to a bond hearing through a separate action for habeas relief in another jurisdiction. But for the most part, we're just seeing federal judges dodge the issue entirely, at least for now, while the appeal to the Ninth Circuit is still pending. And federal judges are deciding these habeas petitions based on statutory analysis and due process instead. Next, I want to take a look at the statutes that these cases are talking about. So at the top, you'll see INA 235B, which corresponds to 1225B of the US Code. I've highlighted in yellow that language, the non-citizen shall be detained. So this is what is providing for mandatory detention. And then 1226A of the US Code, which corresponds to INA 236A. I've also highlighted in yellow the language may release on bond or conditional parole. So this is the provision that for decades was
Hola Mary, ¿cómo está usted?
for decades was
Creo que, y gracias por llamar. Sí, creo que
I'm going to go ahead and proceed with my discussion of the statutes. So the 1226A is what for decades has been the default for individuals present without inspection. The Supreme Court discussed this in its 2018 decision, Jennings v. Rodriguez, that it's the default immigration detention provision in removal proceedings typically applies to those in the interior of the country, whereas 1225 mandatory attention generally applies at the border. Now I want to look at some trends that we're seeing in EOIR and also in the federal judiciary. So this is data from Acacia, and I want to go ahead and put the link in the chat. This is a survey. It takes about 60 seconds to fill out, and it applies to individuals who have had bond hearings. And as you can see, we have about triple the number of denials as opposed to grants. And the vast majority of these decisions that you're seeing on this slide were not after a habeas petition. I also want to note that we're seeing a number of grants in the Annandale Virginia Immigration Court. This was from before two judges were removed from the detained docket a few weeks ago, which my colleague Catherine will discuss. And for those cases that you're seeing on this slide that were denied after a habeas petition, many of these denials were based on flight risk, a basis that we're increasingly seeing to deny bond, which Catherine will also discuss. Next, I want to get into some trends that we're seeing in federal courts. This is data that has been gathered from by the American Immigration Council and the University of Iowa Federal Impact Litigation Clinic. So unlike the prior slide, which was about trends in EOIR after December 19th, which was the day after the clarification decision in Maldonado Bautista, these are decisions from prior. So here you're seeing a small number of denials. And then moving on to the next slide, a significant number of grants. And although this data is from prior to December 19th, this trend of a small number of denials, significant number of grants has continued through the rest of December through January and into February. So before I get into some strategy considerations for habeas, I wanted to pause and do some discussion. So first, if you could put in the chat, if you have filed a Yajure-Hurtado habeas petition, what was the jurisdiction and what was the outcome?
It's great. I'm just starting to read them out for folks in the replay, not who don't see the chat. EDVA granted, grants and SD, I believe that's Indiana. ENDL and WDMI have all been granted. EDVA granted, habeas denied bond with IJ Gardy, finding flight risk and danger. WDKY granted very fast, within a week. ED, Wisconsin, one granted, one pending. It's great. There's just more coming in, and Kentucky grants, California grants. It's amazing. Georgia, we're seeing a lot in Georgia get granted as well. Massachusetts, one pending in Arizona. California granted. So folks are doing really good work. Congrats everyone for pushing back on this.
Yeah, this is very exciting to see the number of grants in the chat. And then for our second question, if you have had bond denied based on flight risk since September. What was the IJ's basis for flight risk?
So several people are saying speculative relief. We just had three people say that. No sponsor. Again, speculative relief, lack of community ties, no application filed, respondent didn't file taxes, lack of credibility. Yeah, a lot on speculative relief. Interesting. I wonder if they're getting guidance on that. And thank you, Adriana, for sharing. It sounds like Georgia Asylum and Immigration Network GAIN has a bond court watch program. They've monitored 950 hearings since 2024, and they've seen a major increase in denials for speculative relief in the last few weeks.
All right, I'll let folks continue to put cases into the chat if you would like, and then I'll go into my last slide on strategy considerations. First, exhaustion is something that needs to be carefully considered based on the client. For some clients, requesting a bond hearing prior to filing a habeas petition runs the risk of getting a bond denial on the merits. This is particularly the case with certain judges being fired or reassigned, or judges changing their decision making. We're less likely to see a judge who would say, oh, I would release based on the merits, but for Yajure-Hurtado. And by filing a petition, a habeas petition first, there are some other types of relief that you might be able to seek. For example, immediate release, bond hearing in federal court, or trying to put certain safeguards into place for the bond hearing before EOIR. Next, I want to talk about rebutting some of the arguments that you might see from the government. One is that the Maldonado Bautista court did not have jurisdiction to issue habeas release to class members outside the Central District of California. In response to this, you could argue that Maldonado Bautista did not even assert habeas claims on behalf of the class. It was only on behalf of the individual petitioners. Plus, many petitioners would not have even been confined at the time that the case was filed. The government may also argue that the district court should stay the case, given that Maldonado Bautista is on appeal. However, in general, a judgment has preclusive effect until it's reversed in an appellate court. The government could also argue that issue preclusion does not apply. However, you could look to United States v. Mendoza, which was decided by the Supreme Court in 1984, which provides, although issue preclusion usually functions differently for the government, it can still apply when litigants were parties to both lawsuits. I think some of these strategy considerations, we're seeing less and less of these arguments from the government, particularly in jurisdictions that have been flooded with petitions. For example, the Middle District of Georgia has adopted a standing order regarding the timelines for the case, telling the government to concede that this petition is similar to previous ones have been decided, or file a response within a matter of days, because judges are feeling overwhelmed by the number of petitions and are wanting to decide the cases rather quickly. All right, so now I will pass it over to my colleague Catherine to talk about bond hearings.
Thanks so much. I first of all wanted to just discuss with you one of the overarching things. And one of this is that we're seeing this as basically a threat to the rule of law and of the ability of judges and adjudicators to make decisions based on the law. I think most of us learned either before law school or the beginning of law school that we have the Constitution, we have statutes, we have regulations, we have judicial opinions. But it seems as if what's happening is that EOR email guidance seems to be trumping all of that. So we're really focused in a situation in which the immigration courts are not are the judges are not being allowed to make decisions based on their view of applying the facts to the law to the facts, but rather are just being told what to do. So I think in that context, thinking through how EOIR has fired immigration judges without cause or notice, sometimes the judge will be in the middle of an asylum hearing and be told you're fired. And that has been happening, maybe not every single time dramatically, but over 100 judges have been fired out of about 700 have been terminated. Some of them have been probationary, but many of them have been long-standing judges who are coming from the prosecution side, who are coming from former DHS attorneys, and also the private bar. And so that is an alarming situation where if a judge is not following the guidance, it seems as if their ability to continue hearing cases is put at risk. Another thing is that there were about 9 Biden-appointed BIA members who also were terminated in 2025. So it's this direct kind of impact on the ability of judges to decide cases independently. Another thing that is increasingly happening is we think that there is email guidance or informal guidance coming from EOIR leadership, which is continuing to replace independent application of law to the facts. I have this here, an image. I just put the image, a partial screenshot here. You can see the full. I would recommend that you look at the AILA alert on EOIR issuing national guidance on Maldonado Bautista. And, Emily just provided this very comprehensive understanding of of the basis for detention, what Maldonado Bautista is, what Yajure-Hurtado is, and instead, we got this 4 line email saying actually Yajure-Hurtado still controls. This was on January 13th after the district court in Maldonado Bautista was very clear that yes, people in this position have a right to a bond hearing. So this is just a very, very odd situation that I think as lawyers we're really reeling from. One issue that we saw in Virginia is the detained court in Virginia is at Annandale. There were 2 detained docket judges out of 3. These 2 judges came from a prosecution background, and actually one was, and they had decades of experience as ICE prosecutors and then as judges, and they were in the middle of their hearings, they were pulled. And the week before, they had been finding that they did have jurisdiction and they had been granting bond. And it was kind of wild for those of us who had been court observing to see these judges pulled off the bench after they had been granting bond to people in the same way that people have been granted bond to for 30 or so years. So that's kind of the beginning of it. And I can go on now to some specific strategies for bond hearing. And just as a reminder, this is for when you are back in immigration court after you have gotten a habeas, after you've gotten an order from the habeas petition that your client does have a right to have a bond hearing. One of the things we're seeing increasingly is a shift from from a kind of more common sense approach to flight risk to a very different standard that we're trying to understand the outlines of. Traditionally, at least in many jurisdictions, we really focused on matter of guerra, which talks about 2 basic things. One is that if you're a danger to the community, you don't have access to bond, and it's your burden to show that you're not a danger to the community. And I think we've all worked a lot on those issues. However, flight risk includes things like fixed address, length of residence, family ties in the US, and the availability of relief, employment history, record of appearance, criminal record, history of immigration violations, attempts to flee, and manner of entry to the US. And there hadn't really been much BIA discussion or much fleshing out of what flight risk might mean. But the BIA is increasingly has published a few decisions that require more attention to be paid to to a sponsor. So if your practice has not been including really full evidence of a sponsor, that's something you should be changing to your practice now to really show how the sponsor is going to be taking an active role in making sure that the client shows up to court, that the sponsor, providing information of the sponsor status, proof of residence, income, taxes, almost anything you can think of. And then another thing is just kind of finding odd ways of denying. So, matter of Akhmedov, where there was some question as to whether this individual really lived in New York or Michigan, and he also didn't timely file a change of address. That was enough for the BIA to overturn a grant of a bond, in that case for flight risk. And so we're finding really strange applications of the law of the judge's just assumptions almost more than anything that are denying on flight risk. It is very possible, given what I saw in the chat, where you all were saying what had been your experiences with flight risk. That was really interesting. All of you said relief speculative. The number of people who said that in the quick way you said it, I am wondering if there is some type of guidance that is telling people to look more about speculative relief, because that shouldn't be the primary consideration. Should be, is the person a danger to the community and will they show up, not those other factors. So that is a real concern. So that's a main takeaway of expecting more scrutiny on risk factors, especially for individuals with no criminal history, individuals who you thought was an absolute slam dunk for a bond release may not be. Another thing, I didn't get this on the slide, but based on a conversations I've been having, is really thinking through how to advise your clients on this, because we're all here because we find it really confusing to understand what the difference is between bond and habeas corpus, and how is it that the government is ignoring court decisions. We're all here because we're struggling understanding this. And so for our clients, really trying to break it down in a clear way, because I think sometimes clients may not understand why you're bringing in another attorney, why you're doing this other thing, what is going on here. And that's a thing where I felt that having longer conversations with my clients to explain to them exactly what this is important. It's challenging because it's challenging for us, and it's even more challenging for a person who may be in detention away from their family and proceeding in a language that isn't their first language. And then moving on, I wanted to just point out one additional thing that I think, depending on your experience of being in bond hearings, is in a long-standing practice, bond hearings are not typically recorded in the way that master calendar hearings or individual hearings are recorded. And because of that, it's important to think through how you can get everything on the record. Again, electronic recordings on WebEx are prohibited. One thing to get around that is to consider having another staff member or volunteer attend, somebody who can take really detailed notes and almost provide a contemporaneous declaration of the proceedings. One thing that's important there is that they can sign it. They can sign it that day, or and then they can actually provide that as some evidence later on, because you, as the officer of the court and as the person representing the individual, you can't be the person attesting to what happened. And so getting a person from your office involved in that role can be really helpful so that you have a contemporaneous record. And then the other thing is to think about asking the judges for a reasoning for why they did this. I've kind of pasted here. I asked the judge. The judge had been granting 1 week and then had gotten this guidance and was no longer granting. Because of that, he was just, going through and saying, "I'm sorry, I don't have jurisdiction. Counsel, Your Honor, would you like to appeal?" I asked him, could you please provide me the citations and what is your basis for deciding this? What are the statutes and the regulations or any other guidance that states this? And so in this case, the judge did provide, a 2-paragraph sentence, 2 paragraphs about why he found that he didn't have jurisdiction. And And he said, even there, pursuant to agency guidance, the Bautista declaratory judgment is likely void with respect to petitioners and custodians outside the Central District of California for jurisdictional reasons. And so he did provide some of those citations. So now, when we are in habeas land, we do have this. And just as a little bit of background for this particular case, this was in that window of, and I think for all of us who have been following this since September. It's like 1 week it's one thing, 1 week it's another. So this was at a time where we thought that if we filed a regular bond motion in good faith, then we would be able to have access to bond. It turned out that the agency guidance came down a day before I was able to be in front of the judge for this bond hearing for this father. And then, just making sure that you're very prepared to just arguing your case as normal and really putting on the record, who this person is and why they deserve to have a process. And I'll just talk a little bit about, just one of my experiences, because as I mentioned, I really focus my practice on immigration court and not on federal court as of yet. I've been very, very privileged to start when all of this was happening, and I had this case that would have been normally a great bond case. I was able to go to lab to Emily's colleagues to say, what do I do here? What's the strategy here? And so from the very beginning, I was able to start working with potential habeas counsel. And I just have, there have been many things I don't like about this situation, namely that this wonderful father of wonderful, wonderful kids in Maryland is detained and away from his family. But I have really liked and enjoyed the opportunity to work with Lab, to learn a lot more about that. And I feel, and also for those of you who are concerned about if habeas is the right thing for you, just the professionalism in federal court, and the opportunities that you have to make arguments that are based on statute, on the Constitution, on due process is really important. And I think a lot of people can find it really refreshing. So I really encourage everybody to go to consider taking on habeas cases when you can. So those are just some of my initial thoughts on the matter. And again, just focusing on just the attention to detail of talking with clients, because this is a complex process for all of us to understand, and making sure that they really understand, and that they have an opportunity to ask questions about why are we choosing these legal strategies when the law is changing weekly.
Thank you, Catherine. And I just want to flag for anyone who is considering getting into habeas who hasn't yet, the actual filing for these Yajure-Hurtado habeas petitions is pretty straightforward now and being routinely granted. So we do have a template we're going to be sending out in the follow-up materials to help you get started. And it's really about making sure you connect with someone who's admitted in that local district court if you're not to be local counsel. But we're going to go next in some discussion questions, and then I'll turn back to the resources.
Thanks, Adina. Our next discussion question: have IJs in your local immigration court been fired or reassigned from the detained docket? If so, can you put it in the chat? What is your local immigration court? And were they fired or were they removed from the detained docket?
Well, folks are weighing in. I saw a couple of questions and comments about how to find mentorship for habeas and being understandably a little anxious about maybe worrying about doing something wrong or the speed of federal court litigation. And I think it really depends where you are in the country. There's various habeas projects that have been brewing throughout the country in different areas. So trying to connect who are providing that in your area. I was going to mention at the next slide, in the DMV region, Amica Center and National Immigration Project have launched a new project called the DMV Habeas Project, where we will be providing some mentoring under that. So please reach out. I'll drop our email in the chat to learn more. And then in terms of Emily's questions, folks are saying, yep, seeing firings in Chicago, Baltimore, Denver, New York. Newark.
All right, and feel free to go ahead and put a few more items in the chat, but I'm going to go ahead and ask the next question. Have the judges that are remaining on the detained docket, have they changed their decision making beyond what new BIA decisions require? We're seeing folks put in the chat in Aurora, Colorado, all IJs who presided over cases in detention were fired except one who retired. San Francisco, EOIR fired so many IJs that they now have to close the court. And in terms of the second question, an example of changed decision making would be finding that something that a year ago would not have been considered a flight risk is a flight risk, or determining that something can't be mitigated by setting a bond amount. No amount of bond would mitigate flight risk. Those are some examples of what I had in mind.
Emily, should I go into resources? Are you still?
Yeah.
Yeah, okay.
Yeah, that's
Thanks everyone for
feel free to
weighing in.
continue putting examples in the chat. We have linked some resources on this slide for those of you that are new to habeas litigation. And when we send the materials around, you'll be able to click on these links. A starter manual for habeas, a compilation of cases that are focused on prolonged detention, a template, Yajure-Hurtado habeas petition, and a couple of trainings. One is an intro to immigration habeas. The other is focused on third country removals. We've also included NYLA habeas practice advisory and a bond quick start guide, which is very helpful for understanding what bond looked like prior to the last 4 or 5 months. Then, Adina, do you want to take the scaling up?
Yes, and apologies, I got ahead of it and started talking a little bit. Just excited because we are really focused on scaling up given the need. And so, like I said, the federal court admission logistically is one of the more challenging pieces because you either have to be admitted yourself or find someone who can be your local counsel. So I do highly recommend getting admitted in the district court where you are barred so that you're in a position to take on these cases. And then for mentorship, if it's not in the DMV area through the project I mentioned, like I said, finding what groups are working on habeas in your area. And then we've heard of a lot of private attorneys just kind of ad hoc partnering up with another private attorney and doing cases together and learning that way, getting some exposure. We've heard of a lot of immigration attorneys who are learning as they go and being very courageous and jumping in and finding that they are able to do this. If you've been able to survive through the wild west of immigration court, you can definitely do federal court. And I think, as Emily was saying, and Catherine, like you'll probably really appreciate how rules are followed and there are procedures actually in the rules of evidence and the law is followed most of the time, I hope. I guess not in every court, right? A lot of people are mentioning Texas getting denials there. So, and then for the DMV habeas project, I mentioned if you are working with clients who are from the DMV region, that's a really good way to get free mentoring and training if you refer them to the project and take on a habeas case pro bono. Even if it's you're representing as a private attorney their merits case and you're willing to do the habeas pro bono, we can train you, and then you'll have that skill going forward for other clients. It's not a problem. We're just trying to get as many people who can't afford habeas counsel with habeas counsel trained up. So a lot of the resources Emily mentioned are just kind of a start. There's a lot more available through the project. National Immigration Project has a ton of habeas trainings as well and resources. We'll be having things like habeas case rounds and all of that and mentorship. And yes, we're going to send the PowerPoint out with the links by Monday. And Monica mentioned a list from AILA of attorneys barred in federal district courts. That'd be great if anyone who has a link for that available to share. And I know National Immigration Project's surveying folks around the country willing to be local counsel as well that can be paired up. Cynthia saw your question, how to refer over. You can just email lab@amicacenter.org for now until we have systems a bit more set up. So we have a little time for questions. Does anyone have any like substantive or procedural questions about what's going on with these cases right now, how to do them, what it looks like? Feel free to come off mute or put it in the chat.
I also just before we get started with that, I also just wanted to thank everybody who has come to us with information about what you are seeing in both the federal courts and in the immigration courts. I think just the collaboration that we've had with Acacia that has been really following through on this, AILA, and so many, just dozens of organizations that have been sharing information is so essential because it means that we're able to know what is occurring, and we'll be, just keeping your eye out on sharing that information. And I think that's been a way that we can be responding as aggressively as we have been, is that.
Someone asked about advice for filing a bond, appealing a bond denial. Catherine, do you want to speak to that?
Yeah, I think you may consider reserving, and I would think through kind of what the basis is for it. If it's the jurisdictional base, I'm not sure how much, and you haven't done a habeas. I guess it depends on what stage you're at. If you're at the pre-habeas stage, I'm not sure how helpful a bond appeal to the BIA on jurisdictional issues will be. You could certainly reserve and just on a case-by-case basis, but if it's afterwards, it's if you have gotten the habeas grant and then are back in immigration court, then you could certainly consider it, especially if you think there are specific grounds for it. But I do think that one of the things we're seeing is that both immigration court and the BIA are increasingly less likely to really consider the law and consider the regulations. And so therefore really being able to be in federal court is probably the best step at this point.
I see Alejandra's question. Hi, Alejandra, about like resources to connect clients with habeas counsel outside the DMV, encountering a lot of fraud. We've heard that too, unfortunately. Do folks have ideas? I mean, I always tend to say like go and check and make sure they're an AILA member at least, because that's often a good sign that they're pursuing training, right? And an attorney, but does anyone else have tips how to verify a good or find good counsel, habeas counsel locally?
I would try and see if there is a regional listserv that you can get connected with to verify attorneys.
Another thing as well is that some of the larger private immigration firms that work in multiple places, they are increasingly ramping up their habeas capacity. And
Yeah.
so I think the first thing to do is if you're like, I don't know who represents in Nebraska, but maybe contact your trusted colleagues in your local area, and they may have said, "Oh yeah, we have a person who actually is barred in Nebraska." So I would look at your local networks as well as the national. I just was able to. I have actually a case I was tangentially working on where the person was detained in Minnesota, sent to Texas, then New Mexico. I ended up being able to connect to a local DC colleague who I have worked with for years. So just keeping in contact with your current networks, because we're just real, like for example, at Amica Center, we're doing an analysis of where were we all barred initially. And so, even if I haven't practiced in that state, I might be able to get admitted quickly. So thinking through those continuing networks, and also think through yourself, where can you get admitted, that you might not have, where even if it's not your main area of practice.
Thank you. And Sarah mentioned relying on local ALA chapter listserv is often a good way to just ask, hey, have you heard of this attorney? What's their reputation?
I was going to address Victoria's question. Do you think it's better to do habeas before filing a bond or after filing the bond? Um, I think, at least for now, with the procedural posture that Maldonado Bautista is, and the widespread non-compliance that we're seeing even after the December 18th decision, in general, I would recommend doing a habeas before filing a bond. Um, in terms of the relief that's available, you could go for immediate release, a bond hearing in federal court, safeguards for the EOIR hearing. And I think doing the bond hearing prior runs the risk of the immigration judge addressing danger to the community or flight risk, which could then make the habeas petition seem futile unless you were really going to go hard on due process issues. So in general, I would recommend doing it before, at least at this point.
I would also add that I think you should be doing the preparation for the bond hearing simultaneously with the habeas, because what we're seeing is habeas is being granted like within a week or 2 weeks or less, a really, really quick turnaround. And so you don't want to be in a position of getting the habeas grant on Friday and having the bond hearing on Monday without having evidence in. I did actually see that in one case I observed where it was another counsel where it was such a quick turnaround that the information on the bond hearing wasn't properly included. So I would really recommend that you have the bond filing almost, maybe just change the cover page and upload the federal court order, and you have your bond hearing ready to go. You've already talked with the sponsor about the fact that they may be called to testify. Everything like that is ready to go, because you don't want to have the government. I think the government wants to take advantage of that lack of opportunity to prepare. And I'm just echoing what an attorney here said, that in Virginia, DHS will forward submit the order, and you'll get the bond hearing in 48 to 72 hours. You must have a full bond filing ready before your habeas petition is decided. And I think that that's pretty spot on for what's happening in Virginia.
I wanted to just bump up to the earlier point in the presentation about release being a potential form of relief in the habeas rather than a bond hearing. Um, especially in these areas where we're just seeing bond denied, like outright. There's more and more courts starting to grant release. Most of them are bond, I believe. But I think we would like to see folks, including our team, pushing more for the court to just order release. That has happened in some courts, so that we don't have to go back to the kangaroo court of a bond hearing. And anything you'd want to add on that, Emily? Kind of like evidence that would be helpful, showing examples of other courts that have done it.
Yeah, I think in terms of preparing for the bond hearings, I think immigration judges are looking for any excuse to deny. In terms of what you can do in federal court to try and avoid that, I think it does vary from district to district and judge to judge. So if you can, try and look at what that specific judge has done. If you're not able to gather that information from Pacer or Westlaw, maybe get connected with other practitioners who are in that specific district. And I think that will give you a good idea of, what all you can ask for, what all that judge will find persuasive, what they've granted previously.
This is great. We're getting a lot of good comments coming in. Anything else you'll want to address before we wrap up? Just being mindful of time. And Lauren, it looks like wanted to clarify whether you're supposed to file habeas and bond, even if the habeas hasn't been decided. No, I don't think that's what we're saying, right? Just kind of prepare the bond, is that right?
Yeah, I would prepare the bond, but not file it yet. If a judge says that you need to have a bond hearing within 2 days or 7 days, especially for a detained client, you want to make sure that you kind of have all the information you need, even signatures ready, because you might have an immigration judge who says, there's not a wet signature on this, this doesn't count. Therefore, you don't have a sponsor, therefore I'm denying. So I think it's really important to essentially prepare the full bond hearing prior to getting a decision on the habeas petition.
Wonderful. Well, thank you all so much for showing up for this and all the resilience that the community has had having to shift to federal court litigation. But we're just really honored to be in this movement with all of y'all and sending lots of solidarity in these challenging times. But yeah, please do stay in touch, and we will be in touch by Monday with the PowerPoint that has the links, our resources, the replay link. Make sure you're signed up to get invites to get those resources and the invites for future roundtables. We do these every other month. So thanks so much. Take care, everyone.
Thank you.